is the quasi judicial meeting procedures. And as I understand, Donna, you have some more on this particular.
Yeah, and I don't want to belabor the point, but I do want to give basically an outline of how I think that it would be advisable to proceed procedurally on Wednesday night. I think the chair would call the meeting to order, and I think at that point it would be appropriate to ask the other members if they feel like they have a conflict that needs to be voted on by the other members. So we went over that in the training, but I just want to put it in order of what should happen. At that point, if there is a member saying that they have a conflict, I think it should be briefly stated, and then the others can vote whether or not to excuse the commissioner from proceeding with the hearing. After that, normally the planning board would ask for all witnesses to be sworn, but I think maybe this time we should do away with that and do it individually, simply because we don't know the number of people who want to speak or to be sworn to testify. It may be a little bit longer in having them individually sworn, but I think it would be cleaner just to, rather than have a massive swearing in, because we don't know how many people are planning on showing up for this. And then I think it would be appropriate for the chair to call on Travis, the county planner, to present the application. That's what he would normally do at the planning board hearings. And I think we should just follow that as closely as we can. And in that, he would present to you the packet. Normally, the planning board has those ahead of time, and I think it would be appropriate for you all to take the packets today, and I think they are prepared for you. The planning board has that information available a couple of days. The packets tend to be rather large. I don't think it's something you can digest in 5 or 10 minutes. So this would give you a few days to look through it and at least understand what the application is. At that point, the chair would call on the applicant to present evidence and swear witnesses. At that point, if you want to swear all of the witnesses for the applicant, you can do so if it looks like it would be feasible to do so. I do not know how many witnesses there would be for the applicant. You can probably ask the applicant's representative and get a feel for whether that's possible or not. And then the applicant would present evidence. You can ask questions of each of the witnesses and proceed at that point. After the applicant's witnesses have testified, you can call on the affected property owners to present evidence. If there's a group that has an attorney, the attorney can proceed at that point and call witnesses. If there are other affected property owners not represented by an attorney, and keep in mind, we have a letter saying that there's one attorney representing, I believe, 6 property owners, but there are 63. So there may be multiple attorneys, there may be multiple groupings. We don't know. So I think at that point it would be advisable just for the chair to get a feel for how many different groups and how many different people are asking to speak. I talked with the county manager about maybe having a sign-in sheet of people who anticipate testifying, of the affected property owners, just to get a sense of what we're looking at. If all 63 want to testify, it could take a while, and we would need to have some orderly method.
There was a note of 30 minutes for each side.
Yeah, and the ordinance does say that the whole thing should take about an hour, and it's within your discretion to give them longer. And again, I think it might be useful up front for you to have a sense of how many people are actually wanting to testify. Even though the place may be full, it doesn't mean that everyone coming wants to testify, or that everyone coming is either a called witness or an affected property owner. There could be people who just want to observe.
To reiterate, the affected property owners are those property owners within 2,000 feet of the proposed tower.
There are the 63 on the list of people within the 2,000 feet circle, that's correct.
How did we get to 63?
How do we get to 63? How did we get to 63?
We go online, Travis goes online, and he measures out the distance from the property itself, and that's how we do it on all of them. And then that's how we measure 2,000 feet. And then we highlight all the properties at that point. We have addresses that we can mail the notification to. So we mailed out 63 notifications.
And that's not unusual. Sometimes it's even more.
Okay.
So that's my proposal. It's just a proposal. You can do what you want, but I was just trying to think of an orderly way that as close as possible reflects on the procedures that the planning board uses, but then adapting it a little bit for potentially more affected property owners than normal.
Questions? This this is the time to bring the discussions or concerns out. Okay. I guess I'm a little concerned about repetitive testimony, and testimony that has to be based on, help me with the word.
Competent evidence?
Yeah, okay. Not just, I understand if you're an effective property owner and say, I just don't want it there. I understand that, and I might have that same feeling, I don't know. But that's not evidence, is it?
Well, I still think that you should at least listen to any affected
Oh.
property owner that wants to be heard, and then you can weigh the evidence to determine what's competent evidence and what's just merely opinion.
After it's given.
Absolutely.
Okay.
But I would like for you to consider giving any affected property owner the right to be heard.
Does that make sense, Bob?
Of the witnesses or the applicants sworn in individuals, is someone making sure they're bona fide property owners that are within this distance? Or is the general public free to come in and discuss this as well?
I think that's part of the procedure that we were discussing. If we have a sign-in sheet, we can kind of do that screening to determine
Okay,
whether they're affected property owners or called witnesses by one of them.
okay.
Because keep in mind, they have the right to call expert
Yes.
witnesses.
And just sort of to take it, you're referring to the applicant there too, right?
Right.
I'm gonna concentrate on the applicant versus the other affected property owners. The applicants, what they will have is they have that lease agreement that allows them to represent the property owner who is leasing the property for the.
Right.
So what'll happen is Travis will come up, and then the applicant will be there with their expert witnesses, and I'm linking it back to the property owner for you. So they will be there with legal representation, who has the right to represent the property owner, and then that's the applicant also. I guess you're wanting I sort of heard, well, the applicant is a property owner or not, right? So we
I
want to.
stated it wrong,
Okay.
sorry. I was mostly concerned about just the general public
Okay.
coming in, people
Okay.
that are not associated with this group of property owners. So you're gonna screen that with the sign-in sheet.
That was one of the concepts that we were trying to, I was thinking about the sign-in sheet, that instead of waiting till somebody stands up there and gets sworn in and then finding out that they're not part of the 63, was if we had some type of upfront sign-in sheet where I've got a list of affected property owners, and we're basically asking them, are you an affected property owner? Yes, we can look at the sheet, and then, or they could be represented. The tougher conversation there is gonna be, we've got a couple businesses here, so we gotta make sure that, you know, that the person there, we're gonna have to ask them, are they there representing an affected property owner? So, for example, if it's an attorney, the attorney could say, like Ms. Paglin's letter, yeah, I'm representing X, X, and X. So that'll be something that we can do our best to try to get something in front of the chairman's hands before the meeting starts. The only other question I'm trying to work out of my mind is the order. You know, the order normally should be Travis and then the applicant, but then when you start trying to go to the order of the affected property owner, I think the order is at the discretion of the chair. Generally speaking, you know, when we've had these hearings before, the chair generally can help run it, obviously with no objections from the other board members. But it may be wise to get the people, I don't know how the best way to say this, that have an organized presentation ready first.
I think that makes sense. I'm not sure how you're gonna determine that.
I don't know how you determine that, but the example of 10 people standing up saying they just don't want it, and then versus trying to get someone that maybe has legal representation in first, so that, because if somebody has an organized presentation, they may be able to present competent evidence, and then your remaining 20 that didn't necessarily, or 15 that didn't necessarily, they just wanted to show up and say that they didn't want it, and they may stand up and say, yeah, I agree with the competent evidence. I don't know, I'm still trying to work that in my mind, how we work that out.
I'm thinking the attorney would know who she's representing.
Yeah, and so, it may be one of these things after we get a sign-in sheet that you just sit down and sort of develop a strategy. I mean, literally on the fly, right then, that's how we're going to, the whole point is just trying to move this along and get everybody, allow everybody to have the opportunity to speak and do it in a fair and somewhat efficient manner, as best we can.
I had a question about involvement of attorneys, involvement of the applicant's attorney. Would he be able, or would he ask questions of the affected property owners? Or vice versa? Ms. Paquin might ask questions, or I guess you'd call it cross-examine. It seems a lot like court to me.
That's
You have
why it's
an
called
idea
quasi
about-
judicial.
I know, we'll figure our way through this, but
Is that a possible?
I think it is a
Scenario?
possibility, and I also think that if there are attorneys on each side, that one may object to the evidence being presented by the other, and I think that generally what we would expect in a planning board hearing is for the party who's presenting the evidence to be able to do their presentation, and then if the other side has an objection to any of the particular pieces of evidence, just state those on the record.
okay. That helps, I think.
Because, I mean, if it is appealed to a superior court by either side, I think that they would need to know what the objections are from either side.
Yeah, I can't speak for everybody, but I think we want to be as fair and as open and as possible, and to do the best job we can do. You know?
That is the intention.
Yeah.
Understanding we're into some uncharted waters.
Right.
That's probably some of the trepidation.
Yeah, I think from our perspective, we're remembering the days when we were having public hearings about another issue where we had to actually move to this part of school because this room wouldn't hold everyone. So, you know, we don't know who will show up, how many people will want to speak.
And we're trying to prepare, I mean, I think we're gonna have to decide some of this when we show up here, because, traditionally, these planning board meetings, where you'll have 10 people sitting down,
Yeah.
that many?
Yeah, we've never had a problem of not having enough space.
Enough space, or the procedure, don't get me wrong, it's not like they don't follow the procedures, but getting into the crux of whether or not it's an affected property owner or not was not as relevant when you got 5 people sitting in the room. It's relevant when the planning board is making their decision on competent evidence or not, but it's more relevant now because of time. You know, if you got 50 people sitting in there, that becomes a relevant issue versus if 10 people sitting out there. If it's not gonna create too much time constraints, then you just go through the procedure, you weigh it out as whether it's competent or not, and you make your decision. So we're just trying to prepare for maybe a large crowd. Who knows, maybe 15 people show up, I don't know.
We have no idea.
And you will also give us some guidance as far as making the decision.
I'm available for whatever you need me to help with,
I
other
mean,
than
there are
actually
certain
telling you what
questions-
to do. I'm not gonna tell you how to rule on it, but
Oh, no, I didn't mean that.
but anything up to that point, I'm
There are
available.
certain things we can rule on and certain things we shouldn't. That's what I was talking about. Certain things we consider and other things we don't.
For example, if one of the attorneys present objects to a piece of evidence, you know, if you want my opinion on whether it's, you know, it's a valid objection, I'll give you that opinion, if that helps at all, based on the rules of evidence.
But let's say you've heard all the evidence, I think ultimately, yeah, where a lot of the guidance can be from the legal perspective is, yeah, it is very specific why you can approve and why you can deny.
That's what I was saying.
And so that ultimately, whether you approve or deny it, you really have to relate it back to, I mean, it specifically states there's a basis of approval in the ordinance and there's a basis of denial in the ordinance. And somehow or another, when you're making your motions and things of that nature, you've got to relate it back to, you're supposed to relate it back to what the ordinance states. And that's where a lot of guidance can, the cheat sheet right there can be referred to, so.
Anybody else? Well, thank you, Donna, and thank you, Dawn. We'll move on then to the next section of our meeting.